The officer testified that my client was driving a vehicle that was not stolen. He was driving a vehicle with a seatbelt on. There was nothing that my client was doing as he was driving that warranted a traffic stop.
Judgment sprung, in and out, the verdict swung. Oouchie Car Watch, we've just begun. Oouchie Car Watch, we're on the scene. Truth's unraveling, what does it mean?
All right. Court is calling 2024 CR 5244, State versus Jordan Davis. Do I have parties announced for the record for the state? Defense.
Good afternoon, Judge. Alfonso Cabañas for Mr. Jordan Davis.
And are you Mr. Davis?
Yes, ma'am.
All right. You all had a bench trial with the court, and the court, after both parties had rested and closed, the court asked for an opportunity to view State's Exhibit 1 in its entirety. The court did have a chance to review State's Exhibit 1 in its entirety, so the court will hear closing arguments. State?
Your Honor, does the state typically not give closing arguments in trial following the defense?
If they want to. My understanding from speaking with you off the record that the defense didn't really want to do a closing. So that's why I was asking you for your closing. But if that's,
I don't know whether defense counsel wanted to or not. But
all right, defense, do you want to get closing?
Yes, Your Honor.
Okay, then I'll hear your closing.
Thank you, Judge. Judge, as the court was aware during cross-examination a couple of days ago, the only officer that stopped Mr. Davis testified that the alleged traffic offense, that he saw being committed was not recorded. I asked him when I talked and described as to the reason for the stop, he initially said, well, his headlamps were turned off, or he didn't have the number of requisite headlamps as per the transportation code. When he confirmed on the stand that as per the transportation code, my client had more than two, he had three functioning headlamps, so much so that during the video, if the court recalls, the officer testifies that the headlamps in my client's car were working. Therefore, Judge, we have testimony from the officer that the alleged traffic offense of not having any functioning headlights is completely false. Secondly, Judge, after we move on from that point, the officer goes on a narrative in which he's trying to tell the court what the officer, would do in this situation. The transportation code and the penal code don't read that way. The transportation code and the penal code read that my client or the individual who is alleged to have been committing an evading offense needs to be clearly shown as evading law enforcement. If the court recalls from the video, during the entire length of the officer following my client doesn't speed, doesn't turn off his lights, does not drive in excess of the speed limit, does not drive under the speed limit, does not avoid traffic, does not flee from the officer. Additionally, my client goes so much as to take the extra step and notify the officer by turning on his hazard lights. The officer makes it a point to say that there were multiple shopping locations or shopping centers on the left side of the highway in which my client could have turned. Well, Judge, then I questioned the officer on Texas DPS, the driving manual, which states that when being followed by law enforcement, a driver has to stop, or rather must go to the right and stop in a place that's well lit and safe, not only for himself, but law enforcement behind him. So when I questioned the officer as to whether or not my client could have stopped on the right, being that it's a construction zone, being that there was nothing but grass and dirt and it was not lit, the officer said, well, I don't know, but I could have stopped there. As we proceed through the stop, or through the video, Your Honor, again, you continue to see that at no point in time did my client commit any additional traffic offenses other than the alleged traffic offense, which again was not recorded. The officer testified that my client was driving a vehicle that was not stolen. He was driving a vehicle with a seatbelt on. There was nothing that my client was doing as he was driving that warranted a traffic stop. As the officer continues to follow my client with his hazard lights turns to the right as he should, and then parks in an area where the officer testified there's no cars coming back and forth, thereby making it safe for my client and law enforcement to continue this interaction. And so the point of this, Your Honor, is that at no point in time did my client evade any arrest or detention. My client simply drove to find a place to stop. We know that he did not flee. We know that he didn't even intend to evade arrest or detention. He was simply looking for a safe place to stop. And as he was doing so, he notified the officer behind him by turning his hazard lights and maintaining a safe rate of speed. And for those reasons, Your Honor, I ask the court to find my client not guilty of the offense of evading arrest or detention.
All right. State.
Defense counsel's arguments are well made, but at certain points logically inconsistent and at other points irrelevant. Mr. Cabañas points out that the deputy's testimony was that Mr. Davis had 3 headlights on. Now, if Mr. Cabañas means this to mean that the high beams were on, then Mr. Davis committed an offense by having his high beams on within 300 feet of oncoming traffic. In which case, Mr. Davis committed an offense of the transportation code.
Was there oncoming traffic?
There was, Your Honor. And
Okay.
we'll be able to see it from the officer's dash cam recording. So Deputy Enriquez did have reasonable suspicion to detain the vehicle. Moreover, case law is clear. Under Lopez v. State, the Court of Appeals for San Antonio stated that although the officers agreed that Lopez was not accelerating from them or driving recklessly after exiting the highway, fleeing is anything less than prompt compliance with an officer's direction to stop, and fleeing slowly is still fleeing. So the fact that Mr. Davis did not speed or travel under the speed limit, the fact that he did not weave in and out of traffic, the fact that he was wearing his seatbelt, these are all very interesting assertions, but they are not relevant to the court's determination of whether he evaded arrest or detention. Finally, there's been no evidence introduced that Mr. Davis was actually following the Texas DPS handbook. There's been no evidence introduced that he's ever read it. There's been no evidence introduced that he was even vaguely aware of it. And so Mr. Cabañas' reliance on this Texas DPS handbook is misplaced because there's no evidence that Mr. Davis was actually following its advice. Even if he were, there were multiple areas for Mr. Davis to stop. The area in which he stopped was not a well-lit place. Deputy Enriquez testified that after the vehicle came to a stop, other vehicles had to go around it. And it's because where Mr. Davis stopped was on a 2-lane road with no bike lane or improved shoulder for him to move into. And so the only place that he could stop was in the lane. So for those reasons, the court should find him guilty.
All right, so you're saying that there is no proof that he knew what was in the Texas driver's handbook, and therefore that should be disregarded? The officer's testimony on the, with regards to the Texas driver's handbook?
The officer's testimony is not evidence that Mr. Davis.
No, that's what I'm saying. You're saying that there's no evidence that he knew about the rules for the Texas driver's handbook.
Correct.
And how is that relevant? Because does the defense doesn't have to present any evidence, correct?
Correct. The defense does not need to present any evidence. But if the defense wants to rely on this DPS handbook for the proposition that Mr. Davis was obeying its advice, then there should be some evidence that he was at least aware of it, much less that he read it and that he obeyed it. And there's been no evidence.
All right. right, the court has reviewed State's Exhibit number 1 in its entirety. I've heard both parties' argument. As both parties are aware, argument is not testimony, it's not the law, it's just your argument. After reviewing everything, listening to the testimony and seeing State's Exhibit number 1, the court will find the defendant not guilty. Is there anything else from either side?
Not from defense counsel.
Okay, thank you. If you will give this to the court reporter, please.
Yes, Your Honor.
Thank you for dressing appropriately for court.
Thank you, Your Honor. That's-
They will be excused, Your Honor.
Yes. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you asking to proceed with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Whenever the court's ready.
I'm ready.
Thank you, Judge. Your Honor, respectfully, today we'd be requesting 2 years TDC for Mr. Moore. He's been in custody for approximately 418 days. I believe the docket reflects 412, but I understand it was printed several days ago. He's a 36-year-old man, Judge, and he has been with the complainant, Miss Capricia Morris, for approximately 9 years, Judge. Ms. Morris does have 4 children, and Mr. Moore has stepped in as a father for those children. Now, he does not have any paternal rights, but he has helped raise those kids for the last 9 years. Ms. Morris has actually contacted our office as well as my client's mother, requesting that Mr. Moore be home. Mr. Moore is motivated and will be dedicated to finding a job so he can get back to supporting those children. And Ms. Morris as well, Judge. And that's the reason we're asking for the 2 years today, as opposed to anything beyond that.
All right, and what is happening with this violation of bond or protective order?
Your Honor, our understanding is that the complainant does not want to proceed to the state will be just to see if the complainant.
All right. And then State, what are you requesting?
Your Honor, the state is requesting 4 years, the 4 years that's part of the corrections. That does have several arrests for assaults. Unfortunately, those were dismissed for missing witness, but this does seem to be a pattern with this defendant. Additionally, as the court can see here, there are 2 cases in front of the court for assault on the same complainant that the defendant does want to go back to. Sometimes, even though the complainant does not want to proceed, it is the state's job to look out for the safety of that complainant and the safety of that community. So for those reasons, the state is asking the defendant to be sentenced to 4 years.
All right, is there anything you wish to say, sir?
I have learned my lesson, Your Honor, and I would like to go home and be with my kids. I love them and support them financially, and would love. I've been here over 400 days, Your Honor, and what I did was while I was here, I signed up for GED, and I just want to go home and take care of my
You signed out for what?
GED.
All right, so here's my question. I read the police report. Why did you hit her?
Allegedly,
Well, no, I mean, I read the stipulations, and according to the stipulations, what it says is, I spoke with the victim who stated that the suspect, that's you, had struck her
Yes, ma'am.
earlier in the day. The victim stated that the suspect took their daughter's phone. Victim stated that when she attempted to get the phone back, the suspect struck her in the right side of the head 1 time with his hand. Victim had 2 visible bumps near the right temple. So, explain.
I had to be stressed out or going through something, Your Honor.
So, is this the first time you've ever hit her?
Yes, ma'am.
All right, and what is this violation of protective order about?
I can't be with her. Is that
No. Yes, so let me ask everyone, the violation of protective order, is that offense alleged to have been committed before or after this incident? Right, so it appears that you have anger issues. So what were you going through that caused you to hit someone that I'm assuming you love?
probably had to been probably alcohol was involved, Your Honor.
Mhm.
And I don't drink no more. I don't smoke. I don't drink. I don't even smoke cigarettes no more, Your Honor. I'm like spare time all I do is read the Bible and learn the good gospel of the word.
All right. This is what the court is going to do. The court is going to find you guilty. The court will give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Capricia, Kaprisha, Lavon Morris. There's a $1,500 fine, time and money to run concurrent, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you. We can go off the record. Here's the thing, you can't hit people that you claim to love. You understand?
Yes, Your Honor. I understand.
All right, good luck to you, all right?
Thank you, Your Honor.
You're welcome. Thank you so much.
Thank you.
Your Honor, if we may, would you consider an application for short probation if you were to follow?
No. Yeah. All right, we're gonna go on the record. And I believe the cause number is 2022 CR 11860. Is that correct?
Yes, Your Honor.
State of Texas versus Dominique Nicholson. Do I have parties announced for the record for the state?
Ashley Jones.
Ryan Ephraim for Mr. Nicholson.
And are you Mr. Nicholson?
Yes, ma'am.
All right, you had a jury trial. And the jury found you guilty of count 1 of aggravated assault with a deadly weapon.
Yes, ma'am.
And they found you guilty of count 2 of unlawful possession of a firearm as charged in count 2. And you elected to come to the court for punishment. Are both parties ready to proceed with this phase of the trial, state
Yes, Your Honor.
defense?
Yes.
All right, state, if you would read out the enhancements.
Yes, Your Honor. The state did file 2 enhancements. To the Honorable Judge of Said Court, now comes Jody Gonzalez, Criminal District Attorney of Bexar County, Texas, by and through the undersigned assistant.
You may want to slow down.
Sorry. And just so I'm aware, Judge, do you want me just to read the enhancement paragraphs, or would you like to read the entire motion?
Just the enhancement paragraphs. In state, defense, do you stipulate that you are in receipt of the
Yes,
enhancement allegations?
I am acknowledging and stipulate I have received the notice, yes.
All right.
So then I'll just read the enhancements. For count 1, before the commission of the alleged offense in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996, and cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas, the defendant was convicted of the felony of aggravated robbery with a deadly weapon, resid gun. And before the commission of the primary offense and after the conviction in cause number 94 CR 5960 was final, the defendant committed the felony of assault, family violence enhanced, and was convicted on the 29th day of January 2013 in cause number D-1-DC-12-904040 in the 427th District Court in Travis County, Texas. For count 2, the state is alleging that the defendant is a repeat offender, and so before the commission of the offense alleged in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996 in cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas. The defendant was convicted of the felony of aggravated robbery, deadly weapon, resid gun.
All right. With regards to the enhancements in count 1, both enhancements, how do you plead? True or not true?
Not true.
And with regards to the enhancements as read for count 2, how do you plead?
Not true.
All right. Are there any opening statements from either side?
No, with the state will waive opening.
Wait, opening.
All right, state, you may call your first witness.
Preliminarily, the state, that, Your Honor, the state would like to offer and admit all testimony and evidence that was heard in the guilt innocence phase of trial.
I believe the judge can take judicial notice of those things.
All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well
Yes,
from the
Your Honor,
prior testimony.
and all the exhibits as well.
Yes.
Right, then the state would also offer State's Exhibit A into evidence pending any objection from defense counsel pursuant to Rule 902.
I object on lack of proper foundation and link to defendant. And hearsay.
All right, the objections as it relates to hearsay, those will be overruled. It appears to the court that State's Exhibit A is a authenticating document. However, with regards to whether or not this is connected to this defendant, then that objection will be sustained.
And Your Honor, if the state could respond, the state would respond that that goes to weight, not necessarily admissibility. It is a self-authenticating document.
No, I'm overruling her objection as far as that this document is not what it purports to be. It is self-authenticating. But what the part of her objection that I'm sustaining is that State's Exhibit A has not been tied to this defendant.
Well, yes, Your Honor, I understand that.
So foundation will have to be laid to somehow tie this document to this defendant. And excuse me, off the record for a moment, could somebody print me out the state's motion for enhancements just so that I can have it? Because I just want to, oh, thank you.
Yes.
Yes. All right, so so far the objections to State's Exhibit A will be sustained unless foundation is laid as far as connecting
Yes, Your
the
Honor.
defendant with that document.
All its first witness.
All right.
They will call you Valdez.
All right, Valdez. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Mia Valdez.
All right, state.
Ms. Valdez, could you please tell the court what your area of expertise is?
I'm a fingerprint examiner for the Bexar County Sheriff's Office.
And do you have any, you possess any certification?
Yes, I have a certification in classifying fingerprints as well as identification of fingerprints.
Please explain what those mean.
So we go through a rigorous course to understand the characteristics of fingerprints as well as on-site training to understand fingerprints.
Let's talk about fingerprints specifically. What is it?
A fingerprint is a print that consists of 12 characteristics that can identify an individual.
Have you ever found two different people to have the same set of fingerprints?
No, not to my knowledge.
Can you please explain how you do a fingerprint comparison?
So when we first get the fingerprints, we do look for, like I said, the 12 ridge counts. And we will compare to see if the individual that we do have in custody is the same person that is on the fingerprint itself. And then we do our Henry classification that classifies the specific characteristics of the fingerprint.
Now, if that is your way of doing it, is that the standard way?
That's the standard.
That's the what way?
The standard.
And again, for the record, we could just allow me to be found. Well, any what's been pretty much states exhibit A for identification purposes and states exhibit B for identification purposes. Do you recognize those two documents?
Oh, yes, sir.
Let's start with exhibit A. That's in your right hand. What is that document, please?
The Declaration of Sarah Wright. Is this
If you want to have time to review the whole thing, go ahead.
Yes, sir, if you could please review. This is the judgment, sir.
How many judgments are in that batch?
Well, there's three, sir. I go by this, I'm sorry, there's two.
When I'm looking at 6 exhibit A, what is that?
This is the judgment.
In both of those judgments that you have in your hand is the name of the arrested person. On both judgments.
Yes, sir.
It's the date of birth of the arrested person on both judgments.
Yes, sir.
If you could please move to the documents in your hand, say exhibit B, do you recognize that?
Yes, sir.
What is that?
This is a fingerprint card, or also known as a ink card,
How do you know that's?
because this is what we use to fingerprint every individual that is brought into the jail.
Okay, do you know who took the individual's prints on that card?
Yes,
And who is that?
that is myself.
And how do you know that it's the same?
I'm sorry.
Strike that question. You testified that you were the one that took those fingerprints, correct?
Correct.
Have those, since you've taken them, then changed or altered in any way?
No, sir, not to my knowledge.
Now, have you had time to compare the prints that's in the judgment, this is an A, to the prints that's in exhibit B?
Yes, sir.
And then what was the conclusion of your review?
The conclusion that is that both of the fingerprints did match.
That the single prints for both judgments?
Correct.
And that matches what's in exhibit B?
Correct.
When you compared the fingerprints that's in exhibit B to what's in exhibit A, did you use the same technique that you could have testified to earlier?
Yes, sir.
Could you please state what the name and date of birth is for states exhibit A and B of that individual?
So it's gonna be Nicholson Dominic Demetrius, date of birth 6/23/77.
Is that for both documents?
That is correct.
The summary say would offer states exhibit A and B into evidence.
They have a chance to.
Yes.
Can you take the witness on board diary?
Yes.
Okay. I may be a little confused. This exhibit B. When were those prints taken?
These were taken today.
And so when you were saying that those prints were taken by me, is that the one you were referring to?
Correct.
Okay, and so there's some other prints in the packet, right?
Correct. Here on the back of it.
Okay, but you were not saying you took those prints,
No, I
right?
didn't.
Okay, so you don't know my client, right?
No.
So you can say that the prints match. And you can say that you took the prints of my client today, correct?
Correct.
But you weren't present when the prints were taken originally, correct?
No, ma'am.
And so you can't say you didn't witness that, or who the person was who gave the prints.
Correct.
I would object to relevance and lack of affirmative link to my client.
All right. And so is the testimony,
I'm sorry.
was it established who these prints and States Exhibit B were taken from?
I'm sorry, Judge.
Was it established who the prints were taken from in State's Exhibit B?
Yes,
She did testify as to me, we have heard that she took about that individual today.
What individual? Do you want to, yes.
Ms. Valdez, you testified that you took the fingerprint stakes at the V today, correct?
Correct.
You see the person in the photo that you took those fingerprints from?
Yes, sir.
Could you please point to that person, identify him by an article photo?
Will be the gentleman in the red.
You represent the records reflect that this is identified the person that you took the fingerprints from, is exhibit B.
All right. Defense, any objection with regards to State's Exhibit A and B?
Every urge the same objections, Your Honor. She has no knowledge of the person who gave the original prints.
All right, those objections will be overruled. State's Exhibit A and B are admitted over Defense Counsel's objection. Yes, please. All right, State, any other witnesses?
Your Honor, the state does not have any other witnesses and the state will rest.
And I'm so sorry, Defense, did you have any, I know you had taken the witness on voir dire. Do you have any questions for the witness?
Well, just, do you know Mr. Nicholson?
No, ma'am.
So the best that you can say is that the prints match, correct?
Correct.
But you cannot say who exactly the person was that gave the prints originally, correct?
Correct.
And you said you use a 12-point ridge identifier, right?
Correct.
But there's actually like hundreds of ridges on a finger.
I wouldn't say hundreds, but there are multiple.
Well, more than 100?
No,
More than 50?
it's a possibility.
Okay. So the comparison is just to a fraction of the points or ridges, correct?
Correct.
I have nothing further, Your Honor.
All right, any further questions from the state? All right, is this witness excused?
Yes.
All right, thank you so much. You may be excused. State, any other witnesses?
No, Your Honor, the state will rest.
Defense, any witnesses?
No, Your Honor.
Defense, do you rest?
Yes.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Yes.
All right. As previously stated, the court is finding the enhancements true. And the court is finding the enhancements true that were read into the record for count 1, and also the enhancements true that were read into the record for count 2. The court will hear argument with regards to sentencing. Mr. Nicholson, you are not eligible for probation from the court. All right.
Yes, Your Honor. The state would like the court to consider state's exhibits 39 and 40, which was entered in the guilt phase of trial. That's going to be the judgment from Austin for the conviction of assault enhanced. And additionally, the fingerprint part that was linked to that judgment in the guilt phase of trial. Your Honor, this defendant does have a very lengthy and violent criminal history. In 1996, he was sentenced to 20 years for aggravated robbery. That's going to be cause number ending in 60 that we entered in today. He was additionally sentenced for burglary of a habitation on that same day. That's going to be cause number ending in 59 that was entered into evidence today as part of State's Exhibit B. State's Exhibit A. Your Honor, he was sentenced in 1996 to 20 years in the Texas Department of Corrections for those crimes. When he was released, it was not very much longer until 2013 that he committed the offense in State's Exhibit 39 for assault enhanced, where he was convicted and sentenced to 6 years. So in 2019, after their 5 years are done, it took him only 3 years to commit this offense, this violent offense, where he shot at an unarmed Uber driver who just happened to be picking up his stepdaughter so that she could go to work. Thankfully, nobody was hurt in this offense. but that's just luck, Your Honor. The capacity for this defendant to hurt people in this community and to hurt his family is shown by the criminal history, and the state is asking that the court sentence the defendant to no less than 40 years on count one and no less than 20 years on count two.
All right, so here's the court's question. And I know that you still have your chance for argument, but I'm reviewing the state's notice of intent to use the two priors.
Yes, sir.
And the judgment that's been given to the court in State's Exhibit Number A,
Mhm.
that judgment is for 94 CR 5960, which you have notice of.
Yes.
And then I have another judgment for 94 CR 5959.
Yes, sir. That is not part of the enhancement. That is just part of his criminal history, and that was provided to defense via e-discovery.
No, what I'm saying is if there is a judgment for D1, DC 12, that one,
Yes, Your Honor.
the court is not in receipt of that.
Your Honor, and that was part of the evidence that was entered in at trial.
All right, if we could have that given to the court, please.
Yes, Your Honor.
Cindy, do you have that one?
I would have turned it in already.
Okay,
No, I may have it in my, let me go check in my office.
all right. I just want to make sure that the numbers are matching up.
Yes, Your Honor.
Let me just check.
All right, thank you.
Recall.
Yes. All right, if you all want to have a seat, I just need to get that document so I can look at it. All right, we're back on the record in 2022 CR 11860. The court is in receipt of State's Exhibit Number 39, which was admitted into evidence during the trial. And the court requested it so that the court could review the cause number that's in that document with the cause number that is in the state's motion to enhance. So if everyone will just give me a moment to review that. All right, the court is in receipt of it. All right, defense?
Thank you, Judge. I know that we've heard about his criminal history and the seriousness of it. I did want to offer some context to that, which starts with the fact that the first offense that for which he did the 20 years, he was actually age 16 when that happened. And he was certified as an adult and sentenced, and he ended up doing most of the time. He really lost so many of his formative years at doing that time, right? And then he gets released and is having trouble and has continued to have trouble adjusting. And the second case, the family violence assault case, he pled to and he acknowledges, and I'm not saying he doesn't acknowledge the first case, but he does ask, and we do ask the judge to consider how young he was at that time. I have had contact with two of his family members, siblings who were not able to be here today. One was a Mr. Paxton and another is a sister, Samantha Romborg. And if I may, they both relate to me the chaotic and troubled childhood that they had, and how, in spite of what you see here today, that Mr. Nicholson was actually a loving and caring brother.
I'm sorry, do you want those witnesses here?
No, I think we discuss it.
No
would be-
objections from the state.
Okay.
That their father was a drug addict, and all the children in the family suffered tremendously, and that Dominic felt an enormous responsibility to try to provide for his siblings, which led him to make very poor choices to accomplish that goal, but that his actual motivation, I mean, and led him into down a criminal path. Which I guess partly was role modeled by his father, but also his sense of duty and obligation to his siblings and having very limited ability and resources to provide for them, and his overwhelming sense that he should try to provide for them really hindered his thinking, and obviously has made extremely poor judgments. I know we stand here today, the jury heard the evidence and returned their verdict. But Mr. Nicholson believes that he can return to society and be rehabilitated. This has been a long revolving door in his life that he is very tired of. And so we would ask the court to please sentence him at the minimum range.
All right, state any final closing argument?
Your Honor, state, that appreciate that Mr. Nicholson was young when he committed the first offenses. However, I think that just speaks to his criminality as prior life, and although the hopes for change are there, according to defense counsel, his actions speak louder than his words, and the court would like, the state would like the court to consider those actions, the harm that he could have caused on October 25th, 2022, and the harm that he has caused throughout his life.
All right. Is there anything you would like to say?
Yes, ma'am.
Here's the thing, if you want to say something, I'll take you under oath and the state will be allowed to question you. I mean, if you want to discuss it more with your attorney.
I like to be over like this, not being able to say it. I won't say
No,
it.
I mean, we can go off the record. Here's the thing. Once you decide to testify, and I think your defense counsel will tell you there are certain appellate issues that may or may not be waived. So it's completely up to you. If you want me to hear what you have to say, I will hear it. What I can tell you with regards to my clients, sometimes they will want to speak, and I would tell them, your family has already told your story. Are you going to say something different than what your family has said? So the state was very generous in allowing your counsel to make a proffer to the court about your childhood.
I understand.
So, but if you would like to say something, it's only fair because I want to be fair to both sides. You don't get to just say something and then that's it. What will end up happening is I will swear you in, you'll be under oath. And if you just want to speak generally to me, you can speak generally. I'm not going to sustain any objections for narrative because sometimes people just want to tell me what their thoughts are and I will listen to them. But that being said, whatever your thoughts are that you want to make sure that I know about, then the state will be allowed to cross-examine. So if that's what you want to do, then we can do that.
I've seen it. I hope. Thank you.
All right.
I guess I would say, I know he feels like he's really in the fight for his life here. And
No, we're not on the record yet. No,
okay.
we're still off the record. Yeah. All right. So y'all ready to proceed? All right. We're back on the record. All right. Mr. Nicholson, this is what I want you to know. No matter what offenses people are alleged to have been committed in this court, it could be offenses that people think are the worst of the worst. I still see everybody as a human being. And when I look at them, many a times I see them when they first start school, like first grade. And I always wonder what made this one child turn left instead of going right. Some people have horrible childhoods and they turn out great. They have a horrible childhood and their thing is, I'm not going to be this way. I'm going to be on the straight and narrow because I need to do this and that. Some people can't overcome it. You know, life just beats them down. And sometimes when you watch movies, when we were growing up, we would watch movies and you see these two children and you thinking everything's going to turn out great for them. And there's one pivotal traumatic thing that happens in their life and it gets them off track and they're never able to get it back in. For example, with you, you went to prison, right? People will go to prison and when they get out of prison, they say they're going to do great things. They're not going to get in trouble anymore. They're going to walk the fine line, right? You get out, you say, I'm rehabilitated, and you say, I'm going to get a job. And then when you try to get a job, people look at your history and they say they're not going to give you a job. And so that's one way where society beats you down. And then you keep trying and you keep trying. And then maybe there's a friend who comes along or somebody who comes along and said, hey, here's some easy money. And maybe you have siblings that you're trying to take care of, try to make sure they don't have to go through what you went through. But at the end of the day, we all got to pay for our offenses, right? Now, do I think that you should get life in prison? No, right? Your minimum is 25 on the first, on count one. It's from 25 up to life in prison and up to a $10,000 fine. All right. This is what the court is going to do. The court is taking in consideration the state's argument about his history, because I have to consider that. But then I'm also taking into consideration what the defense said. And I think everybody would agree for someone to be 16 and to end up being sentenced to 20 years in prison. And I'm assuming he did the 16 when he was at juvenile, but once he became an adult, they sent him to prison with adults. So for a child to end up in prison with adults who have all of their issues, I'm sure they looked at him a certain kind of way. But even though that happens, we can't be in a situation where life has beat us down, so therefore we're going to beat other people down, because then it just becomes a circle. So all of the offenses that you've committed, guess what? That complainant has been traumatized. So there has to be punishment. And you're not eligible for probation. And based upon what I've heard during the trial and based upon what I've heard during this punishment phase, I would not grant you probation, right? Even if you were eligible, because I don't think you're a good candidate for probation. But I also don't think you should spend the rest of your life in prison. All right, so in count one, as previously stated, I'm finding both enhancements true. In count two, I'm finding the enhancement true. In count one, I'm going to sentence you to 30 years in the prison. In count two, I'm going to sentence you to 20 years in the prison. The counts will run concurrently. There's an affirmative finding of deadly weapon in count one, and there's to be no contact with Jayla Satterwhite. Is there anything else with regards to sentencing from state or the defense?
Taking into consideration state also has
All right, and the court will order affirmative finding of family violence.
And I assume the court will be giving him credit for all time served.
Yes, and you'll receive credit for any time served that you've been in custody. And counsel, if you believe the credit is incorrect, just let the court know. We'll make sure that it's corrected. And for some reason, I do not have the trial court certification. I'm sure you probably filled it out before, but do you mind filling out another one for the court?
Okay. Did one or
Yes,
not today?
it's on the wall. And she's going to give you a document that's entitled Trial Court Certification of Defendants' Rights to Appeal. You do have a right to appeal because this is a jury trial that occurred. Do you understand? All right. Your counsel is court appointed. So what will end up happening if she withdraws from your case, a new attorney will be appointed to handle any appellate issues. Do you understand?
Yes.
All right, because this is an affirmative finding of family violence and also because these are felony convictions, and you should know by now, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, do you have any questions about anything?
Just, I didn't hear you, I don't know if you were doing it or not, the fines.
No, fine.
Thank you.
All right, and state the other case.
Your Honor, at this time, there's no, disposition on that case. At this time, I guess if you would like to set it, and it should be resolved by the next court date.
All right, Norma, if you can recall this for Tuesday.
Sounds good.
All right. Here's your document.
Thank you.
You're welcome. We can go off the record. So, Mr. Nicholson, I know it's a lot of time, right? And you have to do half before you're eligible. But guess what? At the end of the day, it's not the end of the world for you, right? You're gonna be older when you are released from prison. There's no ands, ifs, or buts about it. But you can still take this time to try to better yourself while you're at the prison. You can still get degrees. Young people who come into prison, if they're not acting crazy, you can probably give them some advice to help them do better and be better. And you're still alive. You can still pick up the phone, call people. You can still write letters to people. Hopefully people will come visit you at the prison. You can still have that. As long as we're alive and breathing, we have the opportunity to change. You understand?
Yes, ma'am.
So it can still be done. You can still come out and do great things. All right? All right. Good luck to you. We're going to see you back on Tuesday. Okay?
Okay,
All right. Thank you.
thank you.
And we're off the,
You're welcome.
off the record.
Yes.
Okay, so just a matter of logistics on the appeal.
Yes.
I'd file a motion for new trial and then wait to file the motion to it, because I'm not on the appellate wheel.
Well, what we can do is we can take that up on Tuesday
Okay.
because you'll still have enough time. 30
Okay.
days will not have
Right, right, right.
expired.
I just want to make sure I get it in the right order,
Yes.
because I think there was a particular order on the motion to withdraw on the file.
Yes.
Okay,
All right. Thank you. We'll see you back on Tuesday.
okay, thank you, Judge.
Thank you.
Oouchie, watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie, watch quick as a flash.